Welcome to the Commercial Real Estate Show, your source for market intelligence, forecasts, and success strategies. Hello, I'm Michael Bull. Thanks for being with us. Well, today we're going to talk about a subject that's near and dear to my heart. The name of this show is Oops, I Should Have Covered That in the Lease. So look, if you're a landlord, if you're a tenant, you lease office space, industrial, retail, or any type of space, you've probably seen or heard someone say that. So we're going to cover a few of those items today. So if you're a landlord or tenant, maybe you will not make that mistake and be saying that. Please welcome my first guest. It's Laura Hall. She's partnered with Sheley, Hall, Williams, a law firm based in Atlanta. Laura, thanks for joining us.
Thank you for having me.
Now, Laura, you work on a lot of office leases. It's the primary focus of your practice. And, the name of the show is a little bit funny, but it's a little bit scary when you're saying that if you're a landlord or tenant. And we talked about some of the things to prep for this show that there's so many things in a lease that you need to cover. But if we talk about some of the top ones, I think sometimes if you're a tenant especially, an oops could be guarantees. Oops, I personally guaranteed that lease. I corporate guaranteed that lease. But it's also important to look out for that if you're a landlord, right?
Correct.
Yeah.
And there are a lot of oops that you can think of from time to time. With respect to guarantees, if you're a tenant that's providing a guarantee, either as an individual or from a corporation standpoint, the types of things you always want to make sure you include are caps or a limitation on the guarantee. You don't want the guarantee to continue forever. You want there to be an end time when, if I've behaved, I've paid my rent on time, the guarantee should go away. From a landlord's perspective, between an individual versus a corporation, you really don't want individual guarantees. They're very hard to collect on. You have to deal with spousal consents, whether or not the spouse has consented to their joint accounts being subject to a guarantee, which are typically not, and how you really ever recover from an individual. My personal if I have a oops that I want to avoid is don't get one from an individual, get it from a parent company that's probably got deep pockets. And if you're going to have a corporate guarantee or individual guarantee with a cap, make sure that cap includes a cost of enforcement. If you have a cap of $50,000 on a guarantee, you spend $20,000 in litigation recovering from the guarantee, then you really haven't gotten the benefit of your bargain. So that's an oops that you really definitely want to avoid. Another one is if your guarantee burns off over time. If it's a $100,000 guarantee and every year it burns off, you want to make sure that it's tied to rental payments, not simply that the tenant has not committed a big D default. If you have a guarantee that burns off and you just it's an automatic burn off, but that tenant's not paying rent, then you're not really, again, recovering from the guarantor what you had envisioned. So you want to make sure that it's sort of a dollar for dollar reduction. If the tenant pays rent, then your guarantee can reduce. If they don't pay rent, then you're liable for the full amount. We've seen that unfortunately happen where you have, and in this case, individual guarantors whose limitation really gets reduced every month, regardless of whether or not the tenant's paying rent. So avoid that. That can be a real problem.
Yeah. And there's a lot of alternatives, right? So if you're a landlord or a tenant and you're at an impasse on these guarantees, there's lots of ways to work that out. If you have willing parties, right, that have imaginative counsel like you and brokers as well. So one of those is use of a letter of credit. Talk to us about that.
I love letter of credits. If I have a choice and I'm advising a client, definitely go with a letter of credit. They're with a personal guarantee. Those are typically immune from bankruptcy to some extent. If the bankruptcy court consolidates a bankrupt debtor's companies so that you're including the guarantor parent company into that bankruptcy, then you can't really recover from the guarantor because now they're subject to the bankruptcy laws. With letters of credit, those are independent contracts between the bank and the beneficiary, and they're outside the bankruptcy. So they're, to me, a much more sure thing than a guarantee. The things you want to avoid that I've seen in drafting is if you're agreeing to give or to obtain a letter of credit and you're again agreeing to some kind of a burn off, you don't want that letter of credit just to state on such and such date this is going to reduce to X amount, because typically in your lease you've gone to great lengths in putting in there it only reduces so long as the tenant's been current, they haven't been in default the last 12 months, other types of sort of handcuffs on the reductions. If your letter of credit just calls for automatic reductions, then you really, again, you've not gotten the benefit of what you thought you had from a credit enhancement standpoint.
For the listeners who maybe haven't been involved directly in a letter of credit, tell us quickly or efficiently about the process to get one.
Well, as far as the tenant will have to go to its bank and just put up some kind of a collateral to stand behind the letter of credit. The bank will issue a letter of credit to the landlord, which is the beneficiary. We try to negotiate the terms of that letter of credit, which are, if you're dealing with a big bank, they're going to be pretty standard and typical. Then the letter of credit gets issued. You hold it into a vault because it's cash. I mean, whatever you're holding, if you lose that letter of credit, then you've lost whatever that credit is. But I do prefer those over guarantees or cash security deposits.
How expensive are they typically for a tenant?
I don't know the exact amount, and I think each bank varies a little bit, but I would say probably 1% per thousand, something along those lines. So it depends on how big the credit is. It will obviously dictate the cost. But I find them to be much more secure than any other type of credit.
Right, and you've mentioned burn off, and I think 90% of our listeners know what that means. But that's typically when maybe you're personally guaranteeing it for the first 3 years or something, and then that kind of reduces over time if you've been a good boy. Right?
Exactly, exactly. Or it expires. And if it expires, you want to make sure, sort of other things to avoid. You want to make sure that it expires only as to future obligations. So if the date it expires, that tenant still owes $25,000 in rent, that you haven't now lost your guarantor. That they're still liable for the things that accrued prior to the expiration date.
Right, okay. And then I've seen some where they're guaranteeing maybe the tenant improvement dollars the landlord spent, and maybe any other cost to get that lease in place. I've seen that as well, so that's limited to that, and that can amortize down as well.
Absolutely, and it should. I mean, those are built into the rent payments. So if you're amortizing guaranteeing really the amortized or unamortized out-of-pocket expenses, those will reduce over time because, again, as long as the tenant's behaving and paying rent, then you're going to be recovering your out-of-pocket expenses.
Yeah. One of the arguments I've had sometimes with a tenant that didn't want any guarantees, it's like, well, what about this one? If you're in the space and not paying, you're guaranteed. So you tell me this, if you can't pay, you get out.
Right.
I won't go after you.
You pay, you stay.
Right. And sometimes they're like, okay, I get that. Yeah, I won't just use your space and not pay you. And that'll kick in. Any other thoughts, ideas for kind of working these out when there is an impasse for?
I think if you can negotiate, a lot of times tenants will push back because they don't want to spend the money on a letter of credit, depending on, again, how much you're asking for. The impasse is trying to negotiate some kind of a reduction in the liability over time. That's probably your biggest leverage is we want a personal guarantee, or we want a corporate guarantee, or a letter of credit. But if at some point in time you've paid your rent, you've done what you're supposed to do, we'll forgive that, or we'll let it burn off. So that's really probably your biggest negotiation point.
Yeah. Another thing I've seen too with guarantees is that, when we're repping tenants, we have a long interview process with all the players and try to figure out, hey, what are the major important things? And if that's an important thing for you as a tenant, you better put that in the LOI in the beginning.
Absolutely.
Right?
Yeah.
Just let it be known up front that, hey, there's no guarantee.
Right.
Just look at this entity, right?
Right.
So it doesn't get, you don't get down the road and go, all right, now we've got an impasse.
Yeah. Right, and the struggle with the LOIs is that oftentimes the tenant hasn't produced financial statements yet. So when you're negotiating these LOIs, you always have the carve-out security deposit, credit enhancements, always subject to the landlord's review of whatever your financial information is. And so oftentimes that comes during the course of negotiations, which then tenants don't like because they don't want to have to post a security deposit, they don't want to post certainly a guarantee, their parent companies don't want to provide one, and then of course they don't want to spend the money for a letter of credit. But if you can get that information to them up front, then you can alleviate a lot of
Quick answer.
Thanks.
As a lawyer, you're doing the lease, and you're just now seeing the LOI. You prefer one that's 12 pages or two?
Two. There is an absolute two on that.
Okay. Well, there's a lot of other major points on, oops, I should have covered that in the lease. So stay with us. We'll cover those, including operating expenses and controlling them, and also options to renew if you're a landlord or a tenant. They're very important. Stay with us. I'm Michael Bull. This is the Commercial Real Estate Show. We'll be right back. Hey there, thanks for checking out the Commercial Real Estate Show. Don't miss a video of special interest to you. Be sure to subscribe below. And if you appreciate the videos, be sure and thank our sponsors. There's a link to more information about them in the description. For more videos, podcasts, and articles, check out CREshow.com.